We're going to call the next case. People versus Keith Wood. This is a full grant with 30 minutes of argument per side as well.
Thank you. Good morning. Looks like we cleared out the courtroom for you.
Apparently they weren't here for you.
That's right. May it please the court, Dave Coleman appearing on behalf of the appellant Keith Wood, who is present today. Also at council table is co-counsel Stephen Coleman. I'd also like to thank Professor William Wagner, Attorney Jack Jordan, and our paralegal Joe Townsend for all of their assistance in this case. We're asking you to reverse the Court of Appeals today in this matter for the following reasons. One, the statutory issues we raise, the interpretation of the jury tampering statute, and when does a person become a juror. Secondly, the constitutional issues of the violations of Mr. Wood's First Amendment rights to free speech. And then finally, third, the due process vagueness over breadth issues. All these issues are reviewed de novo. So first, I'd like to address the statutory issue. MCL 750-120A, the jury tampering statute, says a person who willfully attempts to influence the decision of a juror in any case by argument or persuasion, other than as part of the proceedings in open court in the trial of a case, is guilty of the misdemeanor. Mr. Wood stands convicted of tampering with a jury that never existed. We agree with Judge Murphy's dissent and his finding that Mr. Wood had no interaction with a single person who was a juror in any case. We believe his analysis, as we rely on in our brief, is correct. Let's look at the actual elements that the trial court gave to our jury in this case. One, that Ms. Johnson and Mr. Vries were a juror or jurors in the case of People v. Yoder. Two, that Mr. Wood willfully attempted to influence that juror or one of those jurors by the use of argument or persuasion. Three, defendant's conduct took place outside the proceedings in open court in the trial of the case. So let's look at each one of those. The first element was not proven, could not be proven. Ms. Johnson and Mr. Vries were never sworn in. They never served as jurors in the case of People v. Yoder. That's uncontroverted. Merely being a juror is not enough. This element required them to be a juror in the specific case of People v. Yoder. No jury was ever chosen or sworn in that case. They were not jurors in that case because no trial ever occurred, and we were even barred from arguing that point to the jury. Even if you accept the prosecutor's claim that they were jurors once they were summoned, that's not enough. The jury's summons notice did not state, when people were called in, that they were coming in for the People v. Yoder case. It didn't say that, and that's uncontroverted in the record. They were never jurors in that case. The second element could not be proven. For all the same reasons, there were no jurors for Mr. Wood to attempt to influence. There's no limiting principle here if you accept the other side's argument. Mr. Wood allegedly tried to influence them to do what? Follow their conscience? How did he try to influence the summoned individuals to make any decision in People versus Yoder? One way or the other, he didn't do so. The brochure he was handing out, which you have a copy of, said absolutely nothing about People versus Yoder.
To be the devil's advocate, isn't it the obligation of the juror to reflect upon the law as opposed to their own conscience?
Of course. The court would instruct them and give them jury instructions, and of course. I'm not getting into, I don't want to debate the efficacy of our client's brochure. That's not the issue. The issue is he was handing it out. It had educational information in it. You could agree or disagree with it. That's not the point. It's the free speech issue. And were these people jurors? So I understand your question, Justice Martman, but that's really not the main issue here.
Well, there's no question these comments would have been protected by the First Amendment in almost any venue other than the one in which they occurred. The question here is, are statements that would otherwise be protected by the First Amendment protected by the First Amendment in this specific context?
Right. And again, remember, he didn't do this inside the courthouse. He didn't do this after a trial had started and people were selected as jurors and he handed them information. This was before any of that happened, which of course it never happened. And he was outside in the highest protected area in our constitutional framework, a public sidewalk.
Was it your
And so-
client's intention to impact the jury on the Yoder case? Was that his intention?
His intention was to let people know their rights as jurors. So he had no connection to the Yoder case, to the defendant, to the defense counsel.
Let me just ask some questions, because
Sure.
I guess the question is whether there's circumstantial evidence that he was in fact interested in that case, right?
Sure.
So he had, from my understanding of the facts, he had attended previous hearings in that case. Is that true?
That's true.
Did he attend previous hearings in lots of other cases in the courthouse, or was he just interested in that case?
Well, he'd been to the courthouse for other matters. He actually been called once himself as a prospective
But
juror.
did he
so-
attend hearings on other cases that he had no
Not that I'm aware of.
relationship with?
Not that I'm aware of.
I thought the evidence in the record was he called a reporter to talk about this very case.
That's true.
And he showed up on the trial date of this case.
Right, but he didn't know
So,
that this
I
was
mean-
the only case that was set for trial that day. He
I
was unaware
understand,
of
but I
that.
mean, it's hard to say that he wasn't showing an interest in this case, right? I mean, obviously, there's enough evidence from which a jury could conclude that your client had a specific interest in the outcome of this case.
Sure. We're not arguing, again, his interest in the case or the content of his brochure. What we're arguing is he's charged with a specific crime of jury tampering of jurors that were never jurors. And so all of that intent and all that, and again, we get into this, and I'll talk about it in a minute, there's no intent exception
There's
to the
two
First
issues.
Amendment.
There's a statutory issue and there's a constitutional issue.
Yes,
You
yes.
started with the constitutional issue, and the question there, I think, is only, it's pretty simple, whether a juror, the juror, as it's used in the statute, the ordinary meaning and understanding of that term when the statute was enacted, whether that includes not only a person who's a member of a jury, a seated juror, but also whether it includes a person who's summoned to serve on a jury.
Right. So that's why I've led off with the statutory argument, because obviously if the court rules our way on that issue, then you never get to the
I
constitutional issue.
understand, but
So-
I'm looking at a definition in Merriam-Webster that says there's two subsenses of the word juror. One is a member of a jury, and 1A, and 1B is a person summoned to serve on a jury. And that's pretty much how the word has been defined and was defined at the time the statute was enacted, so that those, there are certainly indications in dictionaries, lay and legal dictionaries and other case law that would indicate that at least one possible interpretation is that the common understanding of the word is that it included both seated jurors and prospective jurors.
Well-
And so, I mean, I'm just, again, just trying to understand, before we get to the constitutional issues, which I think are very interesting, it's hard for me to agree as I sit here with your position that your client, there's no evidence from which the jury could have concluded that he was there trying to influence prospective jurors on this particular case, of which he had already shown an interest, and he's handing out brochures that, the message of those brochures, although they're no doubt protected by the First Amendment, as Justice Markman mentioned, within this context, it seems to me the jury could easily infer that he was trying to influence the outcome of this particular case of which he was interested in.
Again,
Why is that,
Justice-
why am I wrong? Where am I?
Well,
where am I
again,
misstepping?
you're focusing, just like the Court of Appeals did, on only one element here. That's the second element, where you're talking about willfully attempting to influence a juror. But there are two other elements. The first element being that Ms. Johnson and Mr. Reeves were jurors in the case of People v. Yoder.
Well,
They were not.
that gets to my point. If it includes a person summoned to serve on a jury, then that would take care of that. So it depends how you would define the word, or what you think the ordinary meaning of
Sure.
the word juror was. when
And
the
we go
statute-
through that extensively in our brief, Your Honor, because the case law is clear. You look at what was the common understanding at the time the statute was passed back in the 50s. Not what it is today, not what it says in a
Well, I
law
agree.
dictionary
I agree,
today.
but I think you would
And we
find-
quoted those.
I think you would find some dictionaries in the 50s that do the same thing that Merriam-Webster does today, which, in other words, they define the two alternate definitions that are at issue here, not as alternate definitions, but as subsenses of the same sense of the word, not to get too technical from a linguistics.
Well, if
standpoint.
there are other definitions, they weren't relied on by the lower courts. Everybody talked about the 4th edition of Black's Law Dictionary, and then the Court of Appeals relied on the 10th edition.
I tend
Nobody
to-
talked about any other dictionaries that are out there.
I tend to do that, to look at.
I appreciate that, Your
Pull out
Honor.
the dictionaries myself to try to determine what the ordinary meaning of the word was. But I'm just trying to understand from an evidentiary standpoint, it seems to me there's sufficient evidence from which the jury, circumstantial evidence at least, from which the jury could infer that your client was trying to influence the outcome of this particular case. And I just want to, again, leaving aside for the moment the constitutional First Amendment issues, I'm trying to understand what your position is on that. As I understand it, I think the only contrary point I've heard so far is that although this was the only case in Mecosta County up for trial that day, your client wasn't necessarily aware of that fact.
And it comes down to the definition of the word juror, Your Honor, because even under the second element and what you're saying, an attempt to influence a non-juror is not a crime. And so it comes down to the definition of what is a juror.
So let's say hypothetically that I think that the definition of juror should include a person who's summoned to serve on a jury. I guess we have two additional facts in this case, which are that your client, as it related to one of these individuals, apparently the juror approached your client, but in that exchange, he learned that this person was called for jury service. And then there's a second individual who he approached and asked the question whether that person was called for jury service. So we know with respect to at least two of the members of the public who were entering the courthouse that day that your client was aware that they were there called to serve on a jury.
Well, that was disputed. Our client denied that during the trial. He was just handing it out to people. He said, I didn't.
I mean, it's evidence. We're not here to argue the facts, but there's
understand.
evidence from which the jury could infer that. Let me, if you want me to
Understood.
hedge.
But that leads kind of into the third element, Judge, which is Mr. Wood his conduct had to take place outside of proceedings in open court in the trial of the case. There never was a trial of the case. There never were any proceedings outside of open court. No trial ever occurred.
Wait,
So
where does it say that in the statute?
that's in the elements. I'm going through the three elements that the judge gave to the jury. The third element is that defendant's conduct took place outside of proceedings in open court in the trial of the case. And Judge Murphy specifically in his dissent makes it clear that that type of language and that the statute itself says the jurors are supposed to make a decision in that case. That never happened.
Isn't one of the elements that essentially that this occurred, this attempt to influence the decision of a juror, happened somewhere other than as part of the proceedings in open court? Isn't that what the statute says?
No, the statute, Your Honor, says that
Person who willfully attempts to influence the decision of a juror in any case by argument or persuasion other than as part of the proceedings in open court in the trial of the case. Isn't the idea there that any participant in the courtroom obviously can try to influence the decision of the jury? That's the whole point of the trial, at least one of them.
right.
But we don't
there
want
was no
folks
trial.
influencing the jury outside of that very carefully controlled environment? Isn't that the point?
Right, but the point is it never happened. And that's what Judge Murphy says in his dissent. And look at the statute. It says an attempt to influence the decision.
What never happened? I guess you're losing.
A trial, a selection of a jury in People versus Yoder. It never happened. So how could he have tried to do something outside the proceedings in open court in the trial of a case that never happened? That's our point.
So in your judgment, I just want to understand your position. This
Yeah.
statute only applies after the trial starts.
Absolutely. Or as Judge Murphy said, maybe you could argue at the point voir dire is over and the jurors have been selected and sworn, that it's at that point that this statute takes effect. Very clearly, that's what he said in his dissent, and we agree with him. And we don't think those elements have been proven. But back to the specific question.
Just one interjection, if I
Yeah.
might. So you're not only saying that a juror is not a person who's been summoned to jury duty,
Right.
but a juror is also not a juror unless a trial has been consummated.
Not consummated, Judge.
Begun.
Begun. The voir dire, selected and sworn.
Okay, so
That's what we're saying. That's when you become the juror.
Do you have any definitions in Black's or anywhere else for your definition of juror?
Yes, and we cite them in our brief. The
Would you
fourth
cite 'em?
edition of Black's Law Dictionary in 1955 that was in effect
What does
says
it say?
exactly.
What does it say, please?
It says that you're a juror when you are selected and sworn. That's when you become a juror. That's our point, is that with the common understanding, the common ordinary understanding of the words at the time, back in the 50s, was not if you're summoned, it was you're selected and sworn.
Even if there's a question or if the definitions, the competing definitions and it don't perhaps help us or solve the question. Does this statute in connection or in placement with other statutes, obviously the distinction between 120A and
Yes.
120,
Yeah.
what does 120 inform us if we are left sort of, with no real decision based on the statutory definitions? Can we
Right.
and should we look to its placement in the other statute, with respect to other statutes, and what does that tell us?
Yes, Justice Kavanaugh, and that's another part of our argument under the statutory scheme here, is that 120 and 120A are companion statutes right next to each other. In 120, which is the jury bribery statute, it uses the word person summoned as a juror. It specifically says that. And then the very next section, 120A, which is what Mr. Wood was convicted under, does not use that language and says it only refers to a juror in any case. Now, once again, it comes back, Justice Viviano, to what you're saying. A juror in any case, it's more than just being summoned. You have to be a juror in the case.
I mean,
And that never happened.
That's sort of the nub of the issue.
It really is.
You referenced
Yeah.
Black's Law Dictionary from
Yeah.
1951, the 4th edition. And you're correct, it defines juror. I tend to think the lay dictionaries are more important, but let's, for present purposes, look at the legal dictionaries. So Black's defines juror as one member of a jury, but then the usage note goes on to provide that the term is not inflexible, and beside a person who's been accepted and sworn to try a cause, juror may also mean a person selected for jury service, and that's pretty much how the word is defined throughout the legal dictionaries from that period and throughout the lay dictionaries from that period. So
And that's what the district judge relied on, Judge, was the footnote, which relied on two outlier states saying, we include people summoned. So what was it, Kentucky and Illinois, I think, or something like that.
I don't disagree
so-
with you that those cases which interpret their own state statutes may not give us the answer here. I'm just pointing out to you that the dictionary work, I'm not exactly sure. As I look at the word and I look at the two senses of the word, I'm not sure that I agree with your interpretation that the word is not broad enough to encompass both a seated juror and a person who's summoned for jury service. And I think of that also, I think in looking at, we can look to the statutory scheme, as Justice Kavanaugh alluded to, although I'm not sure that 120 was enacted at the same time as 120A. But,
It was not.
But we should also think a little bit about the purpose of the statute as we can determine from its text. And doesn't that sort of lend itself to a broader interpretation of the word juror?
No, I would say the opposite because of what you just mentioned, Justice. It's the timing of it. The bribery statute was passed in 1931, which used specifically summoned as a juror. The jury tampering statute was passed in 55, which said a juror in any case. So it's presumed the legislature knows the laws they're passing, and this is 24 years later. The earlier law says summoned as jurors, and they don't use that language, and they say a jury in any case. I think the only logical conclusion from that is that's what they meant. You had to be a juror in any case.
Isn't an alternative and reasonable, logical conclusion, alternative to yours, that 750.120A only pertains to jurors, whereas 750.120 applies to a much broader universe of people?
Sure, it's a lot more people, but when they talk about jurors specifically in the statute, Justice, they say those summoned as jurors. It's a different category, and they're very specific in the bribery statute.
Well, but the point is 750.120A doesn't have to, I may be getting these confused here.
That's okay.
The point is 750.120.
That's the bribery statute.
750.120A doesn't have to refer to any kind of modifier or adjective to describe what that provision is applicable to, because the previous provision already makes clear that if you're summoned to be a juror, you're a juror.
No, Your Honor, I don't believe that's a reasonable interpretation because 120 deals with bribery, okay, not with jury tampering, but specifically bribery of public officials.
You just said they
And
were
so-
connected statutes, they were related statutes.
I-
If they're
but
related
that's my point
statutes, they
is-
need to be looked at
Right.
in a
That
relationship.
you look at them together, and because in the one statute they use the word summoned as a juror, and they don't use it in the other, I would argue that the plain and ordinary meaning and the common understanding would be then they didn't mean to include those summoned as jurors. They only wanted jurors in a case to be subject to the jury tampering law. I think that's the only logical explanation we could have.
Well, I don't think it's an open and shut argument that I'm making, but I do think that it is important to understand that
Sure.
the one provision focuses upon jurors, and there's no confusion as to what a juror is in light of the earlier definition.
I understand, Your Honor. And I would also point out, Justice Viviano, in your dissent in Kane, and I understand the Kane decision was only when, dealing with juror oath, and that a jury must be sworn, but you quoted Blackstone in your dissent, and very clearly it says, you become a juror when you're selected and sworn, and we put the quote in our brief, and it's right there. That's what you wrote in your dissent. That's when you become a juror.
That was a great dissent, and I appreciate you.
Yeah, I thought so.
But I would just point out that I looked a lot in that dissent at the definition of jury, what it means to be a jury, so we could determine what the jury oath was. In that
Right.
case, the jury was given the wrong oath, in my view.
Understood,
In
right.
my view, that was reversible error, because
Understood.
I think you're entitled to a jury of your peers
Right.
that are sworn.
And I understand that
And
was
now
the-
we're looking at the definition of the word juror.
Juror, right. And I understand that. That's why I prefaced what I said. I know you were talking about the oath for a jury.
Right.
But you do use that language from Blackstone in support of your position where you say jurors.
just
You
wants
didn't
you
limit
to know
it
that
to
you are
just
brilliant.
jury. It was jurors become jurors when they're selected and sworn.
He makes a good argument.
Yeah.
But, no, it's an interesting point, and I think it's,
Before you move on to the First Amendment argument, language that we haven't discussed in 120A is the language right before juror in any case by argument or persuasion, and that's the decision of.
Yes.
So how does a prospective juror, or someone that's been called to jury duty, make a decision in any case?
Exactly, and maybe I haven't emphasized that enough, but we make that point. Judge Murphy makes that point crystal clear. How can you have a prospective juror who's summoned, even if you think they're a juror, make a decision in a case? It's impossible because they aren't
But isn't
on the
the focus
jury.
on the attempt?
I'm sorry?
The focus, though, is on the attempt to influence.
Again, how can you attempt to influence somebody who's not on a jury to make a decision? It's impossible, Your
well, you
Honor.
can try to get to them before they're seated on the jury, right? Isn't-
Well, but
Didn't
the
you see that?
statute's specific.
Didn't you see Untouchables? Isn't that what happened to Al Capone?
I'm afraid I didn't watch The Untouchables, Your Honor. I'm sorry.
Well, there's a great scene in the movie, and the judge switched the jury right before the trial.
Well, let me just say briefly, I think the Yokin case is really instructive here, too. And I know you have that in our brief. But if a person who's summoned for duty shows up, is inside the courthouse, and this court ruled you're not a juror for purposes of getting money, workers' comp, because they got injured, then how is it possible that Ms. DeVries and Ms. Johnson, who are outside the courtroom and just summoned, are jurors in order to convict our client? That makes absolutely no sense at all. So I think the Yokin case is really critical here.
Can I
Because we look at the
change your-
related statutes.
I'm sorry?
Because we look at the related statutes in this case. And 120A arguably influences the word, 120 influences the words in the later 120A.
But again, it says a juror in any case, and the facts are the same in the sense of when do you become a juror? It doesn't matter.
understand.
Which, so that's our argument, Your Honor.
Can I refocus you now on the First Amendment?
Yes, I'm
Because
running short on time here, so I do want to focus on the First Amendment.
And I just sort of stipulate that the pamphlet your client was passing out, he had every right to pass out that information is legal, what's the message in there, and in many, many settings, he would be able to do that. But as Justice Markman alluded to, why in this context is it a First Amendment violation?
Well, because again, the Court of Appeals.
In other words, he could go to any courthouse in Michigan on any day,
Sure.
or every day of the week, he could pass it out, that broad audiences there, he could go to the shopping mall, he can go anywhere, he could pass it outside of our courthouse
Sure.
today. But why the statute to me seems pretty narrowly focused, and why is it a First Amendment violation?
But it's clear it was content-based. That's why
I
they
agree.
prosecuted him. It's been admitted, if he was handing out other things, they wouldn't have prosecuted. So it's content-based. And in Ashcroft, the U.S. Supreme Court said, content-based prohibitions, especially with severe criminal penalties, have the constant potential to be a repressive force And it goes on and says, those are presumed to be invalid, presumed to be invalid.
But this is
that
not
the government
content- this
bears
is
the
not
burden.
content-based. Content-based refers to limiting, for example, pro-life statements to people going into abortion clinics, but not pro-choice statements in the same venue. Those are content-based.
Well,
This is not, there's no content-based to saying that there is something that's violative of the law, and thou shalt not engage in that.
Well, Your Honor, I would refer the court to our brief. In time, I don't have time to go through. We cite case after case where the Supreme Court has said pamphleting, these sorts of things, expressive conduct are content-based, and they are subject to being, they are protected.
I don't believe that's right. They've said they're content-based when there have been distinctions in terms of what kind of pamphlets and literature can be disseminated and what can't be disseminated.
Well, Your Honor, I think if you look at the Springer-Ertl case, which we cite extensively in our brief, which is the South Dakota Supreme Court, and they cite the U.S. Supreme Court extensively, they say differently. I mean, it's very clear that what our client was doing, that he had the right to do it, it was in the highest protected area, there wasn't a compelling interest to restrict his free speech, and they didn't use any less restrictive means at all. I mean, they used the most restrictive, prosecution and incarceration. That's the most restrictive. What about time, place, manner regulations? What about curative jury instructions? What about a lot of other things that are in all the briefs that could be brought out there? None of those things were done. Just briefly, I want to point out that in the ACLU brief, the amicus brief they filed, they cite the case FEC versus Wisconsin Right to Life. And they say a test focused on the speaker's intent could lead to the bizarre result that identical speech communicated at the same time could be protected speech for one speaker while leading to criminal penalties for another. Under well-accepted First Amendment doctrine, speaker's motivation is entirely irrelevant to the question of constitutional protection. First Amendment freedoms need breathing space to survive. An intent test provides none. So looking at that case and the Springer-Ertl case, where the court very clearly there said the balance must be inclined in favor of free speech by narrowly construing these types of statutes. So the vagueness and overbreadth and due process, we'll just rely on our brief. I hope I've answered your questions sufficiently. I'd like to reserve the last 3 minutes and for any possible rebuttal, and would ask that my co-counsel be allowed to do the rebuttal.
Thank you.
Thank you, counsel.
Brian Thiede, Custer County Prosecuting Attorney on behalf of Plaintiff Appellee. May it please the court. One of the hard things about being appellee is you want to say 4 things first. I'll try to be orderly in my response. Let's start with the statute itself and the definition of juror. I think actually 75120 cuts exactly the opposite of what appellant thinks. It says summoned as. It doesn't say a summoned juror. It doesn't say a prospective juror. It doesn't say a potential juror. It says summoned as what? A juror. No modifier on a juror at that point. Later on in that provision, it says if such juror in 75120. So then we go over to 75120A, and it talks about a juror. It doesn't use any modifier at the beginning in subsections 1 or 2 where it creates the penalties for the jurors. What it does, though, in subsection 3, is it does use a limiting factor for this doesn't apply to a deliberating juror. So what we see from these 2 statutes is juror is this big word that covers all the folks from the time they're summoned until they are discharged. And in fact, really, they carry that identity of having been a juror from their forth because we have a statute for retaliation against jurors for their service. And it doesn't say in the retaliation statute, it doesn't say just for reaching a verdict. It's whatever their service was. Imagine a group threatens everybody, anybody who shows up for jury duty, we're going to get you. Somebody shows up, there's no trial, or they don't get picked for the jury. The retaliation statute can still apply to that because they did their service as a juror. They got there.
What should I make of the fact that in 75120, it is targeted at persons who may serve on a jury and bribery. In other words, the bad conduct is, we don't want anyone who might possibly be a juror to take a bribe. Where in 75120A, it is focused not at all on who might serve as a juror, but on some outside influence. And then in that regard, in those two different contexts, it makes a reference to a juror in any case.
Right. I think there's a couple of things. One is that in 120, you're looking at having criminal penalty against the juror themselves.
Correct.
And this-
Or a potential juror. Because we don't want anybody showing up at the courthouse
right.
who has
Yeah.
agreed to take a bribe if they're selected.
Right, and so there's a very important reason to basically put a juror on notice that as soon as you get summoned, you better not be taking any bribes in regard to anything coming up. That would be one way of looking at it. But it also conditions those other things. Somebody appointed appraisers, somebody appointed this, and I think
You're right, but that's in other words, that statute goes to a much broader class.
yes, a broader class. But again, it still says summoned as a juror, and it goes summoned, that's a subset, juror, big set, includes everybody. And I think 120A goes big juror, everybody, who this can be applicable to.
Oh, no, juror in a case now. That's a subset.
It says, it says juror for
In any
the
case.
decision in any case. And so they're talking there about what is your purpose, what's the intent. It's not the juror has to be in a case, but your intent is to affect the decision of a juror in any case. And we interpreted this, and I think constitutionally and properly, to be in a specific case, meaning you had to be focused on a case in mind, so you can't get the government teacher for teaching something when the person's in high school that they can then influences them when they make a decision as a juror 50 years later.
But
You
Counsel,
have to
I have a question about the nomenclature, which is just like, how do we address in terms of the vagueness or the concern of overbroad, which is just in terms of kind of implementation of a statute like this, wouldn't it be fair to say, and just, help me if I'm wrong, but that the general consensus that people would tend to have is that if I'm trying to understand a statute, you would look to kind of its everyday meaning. And I guess my question to you would be is that the average person would kind of consider the notion of being a juror to be one who sits on a jury, one who is sworn in, rather than a prospective juror. And so, like, for example, doesn't that kind of cause a concern, which is just that the general populace, when they look at this, basically thinks, well, juror means an actual juror, not a prospective juror. And I guess the question is, could this lead to some confusion or a situation where this could be seen as being vague and overbroad just because of the general belief that people have as it applies to just a general description of what a juror is that people would tend to think of?
Not at all, for two reasons. First, just from the average Joe approach, I would encourage you to reread the transcript. It was striking to me how easily people use the word juror. And that when defendant, in his testimony, used prospective juror to try to help his cause, it seemed awkward. People referred to saying, he asked, "Are you a juror?" And they said, "Yes." Some said, "Are you here for jury duty?" Yeah. But when you were asked, "What are you?" Of all the creatures on the face of the earth, are you here to watch? Are you here as a lawyer? We got the attorney things today. We got the visitor things. If they were to ask what sticker we should give you when any of these people show up at the courtroom or the courthouse for that day, they'd say, "I get the juror sticker because that's why I'm here." I think that's the practical thing. The other thing is, this is, again, an attempt statute. And so once we're trying to nip this in the bud, and basically what I would say is by the time somebody is summoned, that individual is sufficiently identified as a juror and sufficiently identified to a case where there will be a decision that somebody who wants to undertake the evil that the statute intends to prohibit knows who to target. And that ought to be the starting place where this statute reaches. That ought to be when we say, okay, now there's sufficient information to say a person who has a nefarious plan in mind can look at the court docket, they can see what case or cases are on, they can wait for the time for the jury to assemble, and they can pass out their pamphlet. And this would go, I think, the same whether there's one case or 5 cases. If you try to hit the whole group, then you are attempting to influence the juror in the case you're concerned with.
Counsel, can you help me understand how to think about the content of the particular messaging as it maps on to the First Amendment questions? So in this particular case, the defendant's pamphlets were about jury nullification.
Yeah.
If the defendant was passing out pamphlets about the burden of proof in a criminal case, pamphlets that correctly identified that the burden of proof in a criminal case is on the prosecution and it's beyond a reasonable doubt, and that's the highest burden under the law. Maybe he even listened to what the judge said in the last case, and so there's nothing inconsistent with what the judge said. Could he be charged with a crime for passing out that pamphlet?
The question there, I think, would be what would their intent be? Is their intent really to affect a decision? Probably not in that case, because they're just reinforcing what the judge would say. That's most of these vagueness or maybe overbreadth.
No, but let's say it is. Let's say he really thinks, he's afraid that the jurors don't really focus enough on it, and it really is important, and he wants to, it really, the burden of proof is a really high burden in criminal cases, and he wants to make sure that, that their attention is really focused on the fact that the burden of proof is a very high one for the prosecution. So he hands out some pamphlets outside the courthouse. So everybody who's showing up, he doesn't know who's going to sit in the case, but they really understand that. Does that violate this statute, and is that constitutional to prosecute him for that? He wants to make sure they really understand that the burden of proof is really high, because he really hopes they acquit.
I think what we have there is that the real problem is how do we prove our case beyond a reasonable doubt if we really think that they are trying to do something to influence a jury? We wouldn't have a case, probably.
So what you're saying is he could be charged and it wouldn't violate the Constitution. You just probably wouldn't charge it because you'd have a hard time proving it.
I probably wouldn't charge it to begin with, because where would I
You
go
might not
with
charge it for all sorts of
And,
reasons,
you
but
know,
I'm just trying to
I've got no
understand, would
place
it
to
be
go.
would it-
And frankly, if defendant had followed the recommendation of FIJA, the people that make the pamphlet, go 2 weeks before, hand them out every day, be sure to go a week after to continue to hand them out, and so make sure that they don't know you're there just for the case you're interested in.
So your view is it's not about the content of the messaging, it's about what he was intending to do. It doesn't matter what the content of the messaging
Right,
is.
the content of the message is not important. For example, if I could indulge me just a second, if we wanted to have a group that was in favor of redistribution by robbery, we could make a pamphlet that would say, we think the government is very ineffective at redistributing wealth. We think we should just rob people and pass it out. We want the robbery statute changed so it's no longer criminal. We have a pamphlet that we're passing out that explains all of our things. And by the way, we are concerned about people being hurt during robbery. And so people, all they have to do is just very carefully give over the money, not try to, especially banks, because they're the place of the money, don't push the alarm, don't do anything like that, and people won't be hurt. In fact, what they can do is put it in a brown paper bag that I've handily attached to this brochure. Now, if I stand on the street corner and pass this out, people are going to think I'm nuts. But if I go to the bank and I give it to the teller, they're going to think I'm robbing the bank because I've given them a suggestion that they ought to put the money in the brown paper bag, even though I didn't say that. I said something that sounds like advocacy for a political position to get rid of criminal penalties for robbery, but really, I'm just setting it up to be a bank robber. And so the issue becomes, in all these cases, and the issue that resolves First Amendment questions is is there a criminal nefarious intent at the end? In fact, in the Holder case, cited in the appellant's reply brief, it gives us a great example. Holder deals with the material support of terrorists. And in that, the court, the majority, deals with and struggles with all the First Amendment questions because the Congress, as they interpret it, had specifically said this material support statute applies to people who want to advocate and materially support in a terrorist organization with advocacy about legal things, and that they intend only to support the legal ends of the terrorist organization. And the majority finally said, you can still do it because of all these things that are bad about terrorist organizations, and they can funnel money and support back and forth. But in footnote 3, and also in the dissent, they gave the other viewpoint. And that's what I'm hoping you folks will do today, is give a definitive interpretation of this statute consistent with what the district court did here. And what that does is, by requiring a specific intent to the willfulness to affect a particular case, makes that the evil that is to be outlawed. And in that Holder case, the dissent...
I just want to go back to, so I'm just still trying to understand if I understand how the intent maps onto the constitutional question, but does the content of the particular message map onto the First Amendment question at all? And I guess your answer is it does not.
The only thing it does in our case is inform the intent of what his intent is. How do we know he was trying to affect an outcome? Because he was saying things that said the government's all
So
bad.
you'll have a much harder time proving intent with a different content than this one, is what you're saying.
Right,
But it's not.
or if he was showing up every day, like Mr. Henklein does, he shows up all the time passing out his pamphlets for jury nullification. He doesn't care anything about a particular case. We had to prove that this gentleman cared about a particular case, wanted an outcome in a particular case.
So let me move my hypothetical in a different direction. If instead of passing out the pamphlets outside the courthouse on the day of the trial, the defendant had mailed them to every single registered voter in Mecosta County, I don't know how many people there are, but assume that was possible.
Be a lot.
Can
yeah.
he be charged?
I think, again, we need more than that he mailed them all out. We need to show some connection between him and a given case, if it was just this pamphlet, for example. Because as you're indicated, on its face, the pamphlet's neutral, like my robbery pamphlet
Right.
would be neutral on its face. It is, as it's in the context.
So, but your answer is maybe. Maybe if you had proof of the reason why he was doing it, say he, admitted it to
I
a
think
witness who was
I
a
think
credible
that's-
witness
that's
that
Honey
he
versus
mailed to
Goodman.
every prospective juror because he thinks he's tired of these
Yeah,
government overreach, and he wants to do something about
Yes,
it. And so,
I think if we have summoned jurors at that point, and his intent is to get them, then I think that's a sufficient attempt, and that's Honey versus Goodman, right on point with that.
so what do you do with the op-ed writer who writes the same thing? If instead the local paper writes an editorial saying, "We're tired of government overreach. We hope if you're summoned for jury duty, you will exercise your rights to nullify. Those rights go back to the Magna Carta. It's like as American as apple pie." What do we do with the op-ed writer? Can he be
Okay,
charged?
it's interesting, and I can't think of the case right at the moment, but it was a contempt case with a sheriff involved in it, and the sheriff did an editorial or wrote a letter to the editor, and they said, no, you can't reach this, but they made a very clear point. The Supreme Court made a clear point. We're not talking about having a jury trial here, and left that question open. I think there's...
So you think it's possible you could charge the op-ed writer?
I would, myself, I wouldn't be charging it.
No, I know you personally wouldn't, but the only way we sort of test the...
I would tell you what the situation is it becomes hard to prove that that's a sufficient, in my judgment, not just mens rea, but actus reus. What have you done to really attempt the offense by then? As you folks all know, statewide elected position is one letter to the editor isn't going to reach everybody. Maybe the letter to every registered voter is a sufficient attempt to do that. But if you're not on social media, billboards, and 27 other things, you'd be hard pressed to say that's a real attempt. So, because we got to have both the actus reus and the mens rea for a conviction to be sound.
So the op-ed
here.
writers should feel safe because it's probably going to be hard to prove?
Because
Well-
nobody reads the local paper.
Okay.
Frank,
Counsel, can I change the hypothetical? I'm not as good at law school hypotheticals as my learned colleague, but I'm going to try here because I think it's, I sort of look at this case from the perspective of a trial judge. I was a simple trial judge from Macomb County and instructed lots of jurors and took some umbrage if I had an idea that somebody was trying to tell jurors something differently than I was when I was instructing them, for example, on the law. And so in this case, when we talk about the content of the message, this is a juror nullification message, but the message just as easily could have been, for example, that proof beyond a reasonable doubt should mean, if the defendant is of a certain, say, ethnicity or race, maybe proof beyond a reasonable doubt should just mean you think they might have done it, and you should convict that person because we have an animus, maybe a racial animus toward a certain group of people. So it doesn't have to just be a message that's trying to let people off. It might be a message that over-convicts people that shouldn't be convicted. And so when I think of the integrity of the trial process, it is that the jurors learn all the facts based on the evidence that's admitted in the courtroom. So we tell jurors, don't go and do your own investigation. Don't go and talk to people about what might have happened. Don't do your own experiments at home. You're not even allowed to talk to your spouse about what they might think about the case. And by the way, all of the information you get about the law in this case comes from the judge, and only the judge. And so what I think of this case and this statute, the importance of this statute, is that it reinforces that it tells folks aren't allowed to come into court. So for example, if this gentleman thought, or any person thought the proof beyond a reasonable doubt standard, that the judge's instruction, they didn't like it. They thought more people should be convicted, not fewer. It's too high of a standard. So if they went to the legislature with a bullhorn, they could do that all they want, right? They can pick it out there, they can have a sandwich board, they can do it however they want to do it. But if they said in court and the judge said, this is the jury instruction on proof beyond a reasonable doubt, which by the way is not a great instruction, but let's say that's the one we give. And then an individual's standing in front of the courthouse with a bullhorn saying that's not reasonable doubt. Reasonable doubt for this group of people that we don't want in our community, reasonable doubt just means they showed up in court. They should be convicted and they should be incarcerated. Should the judge or the prosecutor think that maybe even though they're helping me do my job, I might want to press charges against this person?
Absolutely.
Because of what they're doing to the integrity of the trial process?
Absolutely. We depend on the integrity of the trial process and then jurors being unaffected. In fact, if you notice, our commitment to that, there are only 2 jurors named in the complaint and warrant in this case. Only 2. The reason we only named 2 was those were the 2 people who spoke publicly about the incident, and we found out through public sources. We did not initially, until the other side demanded the list of jurors and wanted to contact them all, we did not initiate contact with any jurors, even though they came there and when they were done with their case, because we feel that, jurors this is the last involuntary servitude in our country. We don't have a draft anymore. We bring in jurors, and that's it. And we try to treat them with the utmost respect and make sure that their decision is made under the law. And that's, in fact, why there are only two charged in this complaint. If I could...
Counsel, by leaving open the culpability of newspaper editors, and I think you've done that, not only referring to earlier decisions that have left it open, you've left it open apparently in your own mind. You seem to be giving some fuel to the argument that 750 is problematic because it violates due process, is unconstitutionally vague. Is there some alternative interpretation under the principle of constitutional avoidance, in which we try to avoid constitutional arguments, in which the scope of this provision couldn't be entirely and reasonably limited as opposed to expanded?
That's in fact where I was going with when I was talking about Helder, because the Helder dissent said, again, this is a terrorist case, the Helder dissent said, all we have to do is interpret this statute to say they have to intend to support the criminal activities of the terrorist group, and there is no First Amendment protection. And so here, the intent, that's why we asked the district judge in this to instruct according to be willful in regard to the specific case, People versus Yoder, and we had to bring in proofs that he had some interest in People versus Yoder, that there was a real intent to affect the jury in that case.
What would be the elements of the crime as you're now describing it?
I'm sorry, I can't.
What would be the elements of the offense as you're presently describing it?
Okay, it is the intent to influence the decision of a juror in a specific case. That's the only thing we kind of beefed up the statute with, if you will. In any case, I think implied that, but, and I think it could have been more effectively written, that you're talking about a specific case. We felt that was the proper construction to be constitutional.
So tell me why the newspaper editor, whose editorials reach 100,000 people in his community, presumably including more than a few actual and potential jurors, would not be covered within the scope of that language.
Generally, I would, I'm not going to exclude the possibility of somebody going way out of their way to do something. But generally speaking, the statement of an editorial position, I don't think evidences a real intent to affect the decision of a juror, generally speaking. And in fact, I remember there was a dissent someplace, or a discussion by Justice Scalia, I think it's in United States versus Williams, where he says a lot of times our vagueness concerns are really concerns about, is there proof beyond a reasonable doubt? Those issues are taken care of within the scope of beyond a reasonable doubt. And so if we require it to be a real intent to have a specific decision in a specific case, then that narrows it down to something people ought not be doing, especially since the actus reus has to be there as well.
I'm just exploring this one, but is it relevant at all in that context in distinguishing between, in your perspective, the defendant in this case and the newspaper op-ed editor, that the former, the defendant, is exclusively focused upon this persuasion element or influence element, whereas the newspaper editor would, even though it's possible that would be his entire purpose, it would be quite unlikely. It would be much more likely that he would have a variety of purposes, including communicating matters of public affairs generally to the people within his circulation district.
Yes, I think that'd be absolutely the situation. You would be talking about somebody he wouldn't write an editor would write an editorial about a specific case with only that specific case in mind.
So how does that fit within the compartmentalization of the elements that you articulated a few moments ago? I
think it does. I think that having to prove that real interest in a specific decision in a specific case is the clincher that makes it all criminal.
I'm sorry to interrupt, but isn't it, you were talking about the facts and the way you approach this case, and I sort of applaud you for the way that you, thoughtful way your office approached this case. Because I think it's really important in these First Amendment areas that we be really careful. But one of the facts that I mentioned earlier to your opposing counsel is that the defendant here, there's evidence that they knew these folks were prospective jurors. And at least according to the Ninth Circuit, in rejecting this type of the mass publication of political ideas, the editorial writer argument, the idea is that if the statute is interpreted to require that the speaker know that he or she's communicating with a prospective juror, then that would eliminate that concern.
Yes, and I think our willfulness aspect, and I should have brought that up, the willfulness is what the jury was instructed on, knowing purposeful.
But it's not just intending to influence the outcome of the case, it's also with knowledge that they are communicating with a juror or prospective juror if the statute is broad enough to encompass both.
Yes, and I think that's a fine interpretation, and I think we covered that within this case. I think it's without necessarily articulating the instructions in exactly that way, I think all of that was included within this case, and the jury was sufficiently instructed to meet that goal to affirm the conviction.
I'm not clear what your view is, if indeed you have one, on the specific question of nullification. Do you consider that if a person attempts to influence or persuade a juror, that he has the right or the authority to exercise nullification, that's more like telling them that, the burden of proof is beyond a reasonable doubt, or is it more like a typically nefarious and corrupt attempt to influence the jury? Or is that just not relevant in this case?
I think in this situation, had we not had information, Had Jeff Roberts, the deputy, not told me right away, that's when he brought the guy in. That's the guy that was at the pretrial who distinguished himself because he was the only person who wouldn't stand up when the district judge came in, and he was smart alecky with the state police trooper and other things. He brought this on himself by being obvious at the pretrial. Had it not been for that and just somebody passing out a brochure, we may have had to send the jury home. That was Judge Jaklovich's determination that we're going to send the jury home, and which is why the case got resolved, why we didn't have a case and all that. But he wouldn't have been charged for just passing out that pamphlet if he hadn't been connected to the case and have some intent with that.
Just passing out a pamphlet pretty much is something that provides you with immunity from the statute.
I would think so, because again, if you are just doing that and you have no view or connection to any specific case, I think you're hard-pressed constitutionally to deal with that. And what you do, if you're...
But you didn't clarify that we were only talking about passing out a pamphlet generally.
Right.
You're saying that if you pass out a pamphlet that pertains to a particular case, that would implicate the statute.
Right, yes. And so if you were to do that more broadly or contextually like here, you're using a specific pamphlet targeting these specific jurors to get the outcome you want in this specific case. That's what fits. If you're on the street corner, in fact, the Denver case is kind of what you're talking about. And around the Denver courthouse, there's guys who have been passing these pamphlets out all the time for years. And what they did is they just have jurors use a different entrance. They don't let those people stand near where the jurors go in, and that's how they've dealt with it, because they haven't had any interest in any particular case. They just are troubled.
I still haven't heard you resolve the question, I think that was initiated by Justice Viviano. What is it that you would do in those circumstances in which what's being urged is, I'm sorry, I'm losing my train of thought here. It'll come to me. Let me skip for a second.
But, you know, there can be other remedies, perhaps contempt proceedings or something along that line. I don't think without the focus on a specific case, I think we'd be hard-pressed to use this statute. Because the decision language, I think, kind of adds to the whole idea of you got to have a focused attention to a particular outcome.
Yeah,
I'm a little confused. Can you just clarify, because earlier you said if he had followed the instructions from whoever produces the pamphlets and had been going every day for several weeks before and a week after, that would have been okay?
No, it wouldn't have been okay, but it would have been hard to prove if that's all he had done.
Harder to prove.
That's the point. If he hadn't gone to the pretrial, if he hadn't called the newspaper, if he hadn't testified about, you know, I had it piqued my interest because what are they doing, telling the guy what to do with his private property, all those things. If he'd followed the rules that they set out, it doesn't make it okay. Because they say, do it a couple weeks before the case you are interested in. So they still are envisioning you trying to affect the outcome of the case.
It would just be harder for you to prove.
And do it by cheating, basically. But the way you get away with the cheating is to go 2 weeks early, stay a week after, and then what's the prosecution going to do? It's not that it makes it legal. It makes it hard to prove that you're guilty.
Okay, so what if you had an individual that this is their cause, and they're bouncing around Michigan courthouses? Every week they go to a different courthouse, and they figure out when the jury is being called, and they don't have an interest in a case, and they hand out pamphlets. They don't speak to anybody. They hand out pamphlets to anyone that will take them.
Well, then what we can do is hopefully pass another statute or have some rules and regulations around courthouses to...
So that wouldn't violate this statute?
It may not, because it's, again, I still think that the most appropriate reading that is for sure not going to be overbroad in regard to First Amendment freedoms is to say there's got to be a particular case you're talking about. You really want to affect one
So you
case.
want us to be narrow?
I want it to be narrow. I think it should be narrow. That's how it avoids any risk of getting into, because it is political speech, if you're not caring about a particular case. You just think the whole system should be turned upside down, and nullification should be the law. And of course, they should probably pick at the legislature as opposed to courthouses. But, you know, that would be more effective.
Although it's arguable that an individual might want to be handing out pamphlets in cases where there's a law that they don't agree with. They're not urging jury nullification in every single case.
Right. Yeah, that'd be
So-
Mr. Henkline. He doesn't like marijuana laws.
Well, so he's probably likely to target those type of cases versus, you know, your general criminal cases.
Right. And in the case that bears his name, he just happened to be out passing them out in a regular basis. He didn't know whether there was a marijuana case coming or not. And so the court says, yeah, you can't convict him because he's just, it's informational in that sense because he's not focusing on any particular case. He's just doing what he does.
Counsel, my train of thought's been at least temporarily restored, so let me try
Okay.
again here. There are different classifications of communications that can be engaged in defendants in this type of case. One would be objective statements of the sort that the Chief Justice referred to, apprising prospective jurors or actual jurors, apprising them of a certain aspects of the justice process, burdens of proof and such. A second would be those kinds of objective statements that is suggested by Justice Viviano actually have an ulterior motive to influence in some inappropriate respect. And third, of course, you have the most obvious willful statements whose purpose is to influence. My question, and it's a follow-up on what I asked you a few minutes ago, if you know nothing else about what has occurred outside of a courthouse, then that the person has either urged or encouraged a juror to consider the nullification process. Where does that fit within that classification? What is your view about nullification, and to what extent did that impact your decision in this case?
Yeah, I believe that what you have there, nullification is an effort to influence, certainly. Because it is going against what the law in Michigan says. So urging nullification is in and of itself an urging to go in a particular direction in a case, different than what the judge is going to
The
instruct.
jury gets an instruction that they can't nullify?
I'm
You say
sorry?
it goes against the law in Michigan. What do you mean by that?
Well, in Michigan, a lawyer is not allowed, a defense attorney is not allowed to argue jury nullification.
I know, but is there any instruction to the jury that they're not allowed to nullify? I mean,
There is not one that, let me just go to this pamphlet particularly.
Yeah, okay.
Because then we don't get into vagaries. There, in this pamphlet, they're saying, don't listen to the judge. It says very specifically, you don't have to follow your oath. And what they use to justify that is, well, we can't really prove it. We're not going to prosecute a juror who has violated their oath. That's the reality. We don't have a forum to find that out typically. But the point is, they are actively encouraging people to violate their oath. And of course, it only goes one way, because we have to pass directed verdict, we have to go through appeal, we have to sustain, you can't have it work where it's to the prosecutor's advantage, where you convict on no evidence, because somebody's going to catch it at some point. But where there's evidence beyond a reasonable doubt, then once the jury says it's an acquittal, I don't have any appeal, we're done. And so it only works as a one-way tool, the jury nullification. And so that's what tells us, or told us in this case, besides the appearance at the court and talking to the newspaper and things like that, what influence the defendant here was trying to have on the process.
thank you. Thank you, counsel.
Any other questions?
We're way beyond time. Thank you very much.
Okay, thank you.
Well, good morning. May it please the court, my name is Steve Kallman. I'm here on behalf of Mr. Wood. I see I only have just over 2 minutes left, so I will try to cram everything in as quickly as I can. I just want to make a couple brief points. The first biggest thing that I heard from opposing counsel is that he couldn't really articulate any limiting principle on where this could be extended to. And I want to use the example of what happened in this very courtroom this morning with the case with the Flint water crisis. Look how many people were here interested in the case. I think it's safe to say that if that case goes to trial, it's very likely that people will be attending that trial, possibly be outside, possibly picketing, possibly having signs outside the courthouse saying justice for Flint, trying to voice their opinion on the case. If you allow the Court of Appeals decision to stand, then if any vigorous prosecutor who sees any protester, maybe someone that was here today, is out on a public sidewalk on that case and says, justice for Flint, and he's able to prove that that person had the requisite intent to influence those jurors or potential jurors, then
Do we want courthouses to be venues for picketing and buttons and bumper stickers urging jurors to do this or do that?
well, and I think that's where the least restrictive means analysis comes into place, Your Honor. I am not saying that people should have carte blanche, be able to say or do whatever they want. That's not what I'm saying. I'm saying that if the court is concerned about those
What's the
issues.
point of raising the scenario you just raised? If it's
Well,
not to
I'll explain
suggest
it.
that was
The
okay?
issue that I'm raising is that if the court is worried about those things, they have many less restrictive means rather than criminal prosecution. They could rope off an area and say, this is the free speech zone. Anyone who wants to picket can go there, and then they have the prospective jurors not go near there. They could do curative instructions. They could even, with valid time, place, and manner restrictions, the court can also limit when people may protest via time. So they could say you could only start protesting outside after everyone's inside, and then you have to stop before they let everyone out. Those are obvious examples of less restrictive means that a court may employ in order to allow people to voice their opinion on cases that have a lot of public import. And I think you saw it this morning. There are a lot of cases that interest a lot of people, and we shouldn't cause a chilling effect on those people where they think, man, I'm really excited about this case. I think I'm really passionate about it. But if I go, I may be prosecuted because they may prove that I had an intent to influence. We shouldn't even be approaching there. We should allow people to have a vigorous debate. And if we need to constrain that within certain areas geographically or time to have the best of both worlds, allow people to have their voice, but also protect the interest of justice, we can do that short of prosecuting everyone that may do this. So I wanted to raise that point. Another point that
We are actually out of time, counsel.
Okay, I will end there.
But
Thank you very much.
The case will be submitted.